Do you own a family business? And if you do, would you like to be able to keep it while you're alive and pass it on to your family members under your will without in Pennsylvania inheritance taxes? If that sounds impossible, it's not anymore. But if so, here are a few more questions for you. Are you a resident of Pennsylvania? This new law and this new process we're about to discuss are specifically for Pennsylvania residents. Do you own real estate or manage real estate? Do you have a service, retail, or manufacturing business? Have you been told that there's nothing you can do about Pennsylvania inheritance taxes unless you give your business or business interests or property away during your lifetime? Have you been mistakenly told that because of the changes in the federal estate tax laws, there just aren't any taxes for your heirs to pay? That's not true. There still are. Have you ever worried about the effect that death taxes would have on your businesses and your ability of your heirs to keep it going and to pay the bills? I mean, if they have to borrow tens to hundreds of thousands of dollars of money to pay inheritance taxes, would it affect the viability of the business? If you've answered yes to any of these questions, then watching this brief report is vitally important to you. It's going to matter. The short time that you're going to spend reviewing this little known information could mean a savings to you or your heirs of tens to hundreds of thousands of dollars in taxes. Taxes that you and they might not even realize right now are going to be due when you die and when you try to pass on these valuable assets. And it's a tax that now can be avoided. It can be totally eliminated in certain circumstances, but you have to know how to do it. The Pennsylvania legislature did not make it easy or automatic. Take advantage of this new legal protection. Look, you didn't work and sacrifice your whole life to lose your legacy to taxes and expenses that can be avoided. So if you're not the kind of person to just sit back and let the government take more than you have to give them, there's now a new way to protect more of what you worked so hard for. So let's get started with a review of what we're going to do in this report. First, we're going to discuss who we are and why this matters to you. Next, we'll review the new law and how it works, what you can and what you can't do. And finally, we're going to give you some examples of how to make it work best for you, some really interesting strategies, and we're going to let you in on a process and a procedure that you can use to make this relatively complicated thing a lot simpler. There's been an important change in the law, and while it happened a few months ago, really nobody is talking about it. Most lawyers aren't even discussing it amongst themselves or with their clients. And the few people that know about it haven't really created systems to allow you to understand the law and, if you want to use it in your favor. But we have, and I'm going to share much of that with you, starting right now. Hello, I'm attorney David Fries. My partner Doug Kahn and I limit our practice to trusts and estates planning, business succession planning, and elder law planning, mostly for affluent families and for family business owners. And we've built a team of lawyers and paralegals within our firm who also focus in these areas. And we're conveniently located in Chester County, Pennsylvania, and we serve almost all of southeastern Pennsylvania. And right now, we're going to begin discussing a very, very important topic for you if you're the owner of a family-owned business and you're thinking about passing this business on to your heirs and successors under your will. Why would you care and why listen to me? Well, you care because you've worked so hard on this business and you want to keep the taxes to a minimum. You might listen to me because I've been providing trust and estates and estate planning strategies and services and legal information and systems to affluent business owners for over 27 years. And during this program, I'm going to give you the information that you'll need to take advantage of these important new tax savings laws that just haven't been disclosed to people. And to help you find out if this amazing new law is right for you. It's not right for everybody. And if it is, I'm going to help you to work with your advisors to save tens to hundreds of thousands of dollars for your heirs. You're going to hear me say that over and over again. It's ten to hundreds of thousands of dollars. If you're lucky, you might also get some lawsuit and asset protection for yourself and your heirs at the same time. And we'll discuss that more later. And I'm going to show you how to determine if you qualify to use these new laws. And if you don't, the amazingly effective ways that you can restructure your family business and estate planning so that it will qualify and you can avoid this tax. In essence, I'm going to show you how to save tens to hundreds of thousands of dollars for your heirs. What the law really means for business families, the pros and cons, and there are a few of each under the new law, and how to make it work for you if you want and need it to. We're going to go over who this is for and who the law isn't for. and why, even though it's great for some families, it might not be for you. But then again, it might be. If you do own a family business and you're even thinking of leaving it to a family member or multiple family members, the information in this report is again vital. Without it, you might never act. You might leave tens to hundreds of thousands of dollars on the table to be swept up by the government, leaving the bill to your heirs. Or you might spend money without realizing that the law won't work for you, and you'll waste the lawyer and accountants and other fees that you've been charged, and you'll still have the taxes and the duties to report to the government without really getting the benefits. Either way, you'd lose, and I want you to win. But the choice is really yours. The law doesn't automatically apply. So spend a few minutes now to save huge taxes, or skip it and saddle your heirs and your successors with a big bill and unnecessary taxes. First, if you've never heard of this and you're skeptical, I understand, but it's probably just because it involves a brand new law, and a law that just became effective but has important implications for Pennsylvania residents that own one or more businesses or who own real estate or other assets that could easily be converted into one or more businesses or structured like one or more businesses. So let's begin and look at the provisions of the new law. It's necessary that we understand that first before we can get to how to really make it work for you. First, we'll define what I mean and the state means by a family-owned business and why the law is so important. This law now allows you, as the owner of what they call a qualified family-owned business, or QFOB, you'll sometimes hear them refer to qualified family-owned business interest, and they allow you to transfer that business to certain qualified family members as the business recipients. They're called qualified transferees. We'll call them QTs. And you can do all of that without any Pennsylvania inheritance tax. This can, however, only be done provided that certain very important conditions are met, both before and after you pass away. There are some things that need to be done on an ongoing basis, even after you leave the asset to your heirs. So in this video report, we're going to take a few minutes and review what qualifies as a family-owned business that can be transferred without inheritance taxes, and we're going to talk about who can qualify to receive those interests tax-free. Next, there's some important strategies that we've really been working on and that you can use to save your heirs all of that money that we've talked about. But before you can really use this to your advantage, you have to understand the basic and most important information. So let's review it and move on to what you really want. How do I make this work for me and for my family? This new law allows the transfers by will of family-owned business interest, but only to QTs, qualified transferees, and only in certain circumstances. And after they get them, they have to do a few things or the tax bill actually comes back to bite them with interest. That tax for will transfers to family members ranges from 4.5% to 12%, and in some cases even to 15%, depending on who the relative is that's receiving it. So that kind of savings might not sound too exciting, right? If you have a business worth $3 million, for example, and you're leaving it to one or more children, it looks like you'd only save $135,000. Now, it does cost some money to get this, but if you were going to pay $2,700 or even $10,000 and save $135,000, would you do it? Leaving it to a brother and sister, you'd only save $360,000. Would you spend $2,700 or $10,000 or even $50,000 to save $360,000? You might. Leaving your business to a cousin, a niece, or nephew, you'd only save $450,000. Not too exciting, right? But there is more to the story. The savings can be bigger for bigger and more valuable businesses, much bigger. And you might think that doesn't make sense because one of the rules that we're going to be talking about is that you can only leave a business worth $5 million. But that $5 million is book value. You see, there's a strategy which, when used correctly, can allow a savvy taxpayer's estate to shelter many, many millions of dollars from tax. Much, much more than you think. However, you've got to know the secret to make it work for you. And I'm going to give you that secret. I already alluded to it, so that you can work with your lawyers and accountants to make this huge tax savings into a reality for you and for your family. The purpose of the new law is to protect certain family-owned business interests from being subject to Pennsylvania inheritance taxes, which might cause them to be sold or which might cause the businesses financial difficulty. You see, Pennsylvania wants to attract and to keep the family-owned businesses that they have. However, the state legislature, whether completely intentionally or not, was very, very generous in the way they created this law and in some of its provisions. Let's take a look. What qualifies as a family-owned business interest? The business has to have 50 or fewer than 50 full-time employees. That's a lot of our businesses. It has to have a net book value of less than $5 million. Now, this is important, and we're going to come back to it later, because for many businesses, the net book value could be much, much less than the fair market value. So you might have a business with a fair market value of $10 million that has a net book value of less than $5 million. It has to have been in existence for 5 years or more prior to the decedent's death when they will the family-owned business to qualified family members. And it must be wholly owned by a decedent or the decedent and family members. That they have to be qualified transferees. And it has to be engaged in a trade or business, the purpose of which is not the management of investments or income-producing assets. And what this means is that for many years we've been helping people to create family limited partnerships that were set up to save money on federal estate taxes. Those might not qualify for this and probably wouldn't if all they own are investment assets. And for that reason, it might be necessary to restructure them and take real estate or other assets out of that kind of business so that they would qualify. The business has to be a direct transfer and it cannot be in trust. Again, this might be a major disadvantage, so more on this later. But what it boils down to is this. You might want your heirs not to have to pay the tax, but you might be very concerned about a divorce or lawsuit, which would cause you to put it in trust. So we're going to talk about how you can handle that sort of dilemma or problem. We have a system. So the second big issue is who is the qualified transferee? First, what qualifies as the business? Next, who's the qualified transferee that can get it without paying tax? Well, these interests could be transferred under a will without tax to a husband and wife, to lineal descendants, such as children, grandchildren, and great-grandchildren, to siblings and siblings' lineal descendants, so brothers and sisters and nieces and nephews, and to ancestors and the ancestors' siblings, so it could be given to a parent or grandparent or to an aunt or an uncle. In addition to these definitions, however, the statute has several other important requirements. The interest must continue to be owned by the QT, the qualified transferee, for 7 years after the decedent's death. And that means that if they do actually transfer it or sell it, that they're going to owe not only the original tax, but the interest that would be paid on it. And it's very, very important to understand this. It doesn't mean that you wouldn't do it. I mean, there are lots of good reasons to still do it, but you have to understand that this is what happens. The interest also must be reported on a timely filed Pennsylvania inheritance tax return. So you have to pick and make sure you have a really savvy executor that will hire counsel to properly prepare that return. There's another requirement that a certificate must be filed annually by each of the qualified transferees for a 7-year period, and failure to do this could result in loss of the exemption. So there are some ongoing costs, and there's some ongoing duties associated with this process. But in most cases, they should be easily outweighed by the benefits of a massive tax savings. You're not going to spend the money to do this, and you're not going to make your heirs jump through these hoops unless they're getting a truly significant tax savings, which they can. Furthermore, if the qualified family-owned business interest is transferred to a qualified transferee, but if it's transferred in trust, it won't qualify. Therefore, it's important to think about whether it's better to save the inheritance taxes or if it's better for the family member to have the creditor protection and the divorce protection and the lawsuit protection that be created only by transferring it to a trust. Furthermore, be careful if your lawyer is telling you to put this into a living trust. That might or might not be a good idea. We've created a system. We've created a system to solve all of these problems and to solve them right now. At our firm, we've created a very, very interesting system and process where we do the following. We help you to figure out if this new law is really going to work for you. And make it work for you. If your business doesn't currently qualify but can be modified, we're going to make sure that we do that for you. We also are creating special wills that will allow you to give the asset to a qualified transferee, but which lets them decide whether to avoid paying the tax, to take it outright, or to transfer it into an asset protective trust if they're facing a divorce, lawsuit, or they're concerned about those. And then the tax would be triggered and they'd pay it. We call this process the QFOB, Business Tax and Protection Process. This is a very, very important strategy and series of strategies. They make it easy for a business owner to use this system, and they make it easy for you to build flexibility into your plan for your heirs. Why? And how? Well, it allows your heirs to decide which is more important, the tax savings or the creditor protection of a trust. And it allows them to do that even after your death when they can best assess the situation. Most lawyers will tell you that you need to make that decision now and you need to put it in your will and then you need to change your will if you later change your mind or if circumstances change. But with our QFOB business protection process, you can do it now and you can leave that decision to each of your recipients to make later when they really know what's going on and what's important to them. So back to the definition of a qualified business interest. Property transferred to the qualified family-owned business within 1 year of the decedent's death is not eligible for the exemption unless it was transferred for a, quote, legitimate business purpose. Well, this is complicated. I bring it up here reluctantly because I don't want to make this confusing, but here's what you need to remember. If you're doing your estate planning and if you're going to put a cash infusion into your family business, you want to be careful and discuss that in detail with your tax and your estate planning advisor, because that might be a problem under the new law. It's an important factor, but it's complicated, so just discuss it with your counsel. Finally, inheritance tax and interest that would be due on the QFOB becomes a lien in favor of the Commonwealth on the real and personal property of the qualified transferees, your heirs, at the time of the transaction. So that's important, and you should know and understand what it means to your heirs. That means that if they fail to file the annual report, or if they sell the property within the 7 years, they're going to owe the tax, and the state has a lien on their property to get it. But they will have had the business tax-free for all that time, and it may have grown enormously, so it may still be a very good strategy to do. So let's talk about that. Let's talk about the strategies for getting the most from the law in your particular circumstances. So now we know a couple of the aspects of the law. Let's look at how we can really use it, leverage it to the max. First of all, one of the most important things that leaps out is that there's no limit on how many qualified business interests you may have. So if you have one business that's got a huge value that takes its book value over the $5 million, then you might want to split that into multiple businesses that you could leave. Thus, if you have a business worth more than $5 million, it can, and in many cases should be divided into separate businesses or corporations so that you create a multiple $5 million or less exemption. This could allow you to pass on an amazing amount of wealth to your family. Therefore, if you have a single family entity that, for example, owns a piece of real estate or a business that could be divided, absolutely discuss that with your attorney and whether or not that should happen. Remember, it must be restructured more than 5 years before your death, or you may only have one $5 million business that's exempt or none that meet the exemption requirement. So you have to be careful about this, and the sooner the planning gets underway, the better. Next, and this is vitally important, this law provides that the valuation of the $5 million threshold is done based on the book value and not fair market value. This gives us a huge amount of leverage, massive, massive business leverage. So, for example, if you own a piece of real estate that's currently worth $8 million, but it's been depreciated and your business has a very low book value, you might be able to transfer the entire fair market value of $8 million tax-free. Why? Because its book value is less than 5. Or you could transfer an asset worth more than $8 million of book value by separating it into 2 assets. So you might create 2 separate companies that own this real estate and are thus worth less than the $5 million. Furthermore, by dividing family-owned businesses into multiple business interests, each of which meet the qualifications, you might be able to leverage this over and over and over again to shelter multiple businesses, which are each worth less than $5 million of book value and might each be worth much, much more in terms of fair market value. So it might be possible to move 10 or 15 or even $20 million of assets free of Pennsylvania inheritance tax. Now remember, when you have assets worth over $5 million of fair market value, you also have to be concerned with and talk to your advisors about the federal estate tax planning issues. And, I mentioned this before, you might also get some litigation and lawsuit protection as well. How? Well, if you separate the businesses, then a lawsuit related to one might not be able to reach the assets you have in the other. We see this a lot with our real estate clients. If you own 3 pieces of real estate all in one limited partnership, and if one of the tenants brings a lawsuit, they could get at the value of all 3 businesses. But if you separate those businesses, or better yet, create separate businesses when you buy the real estate so there's no additional realty transfer tax, then if a tenant in one sues, they can only get at the value of that one asset and not to the others. So you could get some very significant creditor protection as well as saving the inheritance taxes. So how do you go about doing it? And what are the pros and cons? Well, the pros are obvious. You could save 4.5% if the business is being transferred to children. You could save 12% if the business is being transferred to a brother or sister. And you could save 15% on the entire fair market value rather than just the book value of any of these if it's being transferred to nieces and nephews or more distant relatives. A couple of other really important points here. There's some people that you might think would be included in these qualified transferees but who are not. For example, sons-in-law and daughters-in-law, the spouses of qualified transferees, are not qualified transferees themselves, so this needs to be carefully reviewed when deciding what to do. So what's the bottom line? Well, you need to decide. Do you have a family business that qualifies? Or if it doesn't, can it be made to qualify? If you don't have a family business, are you engaged in activities that could be restructured into a qualified family business that would qualify? You need to decide if an existing family business or a reconstituted family business should be divided into multiple businesses. So you could transfer multiple businesses, each of which has a book value of less than $5 million and might have a much higher fair market value. Again, this is going to be particularly important for any family-owned business that's going to be transferred to family members, which has a low book value. Let's take a couple more examples to flesh it out, to decide who this is for and who it's not for. If, for example, you had two pieces of real estate and they could be divided into two separate family businesses, and the fair market value of each was $5 million, that means you're essentially transferring $10 million of value to your heirs. $10 million. That would be subject to a Pennsylvania inheritance tax of $450,000 if it was going to kids or grandchildren. Almost $500,000. This could be saved, however, by dividing this into two businesses, each of which had a book value of less than $5 million. A savings of almost $500,000. Therefore, if the cost of the realty transfer tax, the cost of revising your will, and the cost of some legal transaction fees, you might be able to spend as little as $10,000 on up to possibly $200,000 or anywhere in between, but you'd save up to $450,000. So the question becomes, would you spend $10 or $20 or even $50,000 to save $450,000? You might. On a smaller scale, it might be worth doing too. If you have a family-owned business and it can be structured in a way that the book value is less than $5 million, it could be something as simple as a grocery store or an insurance agency or a retail store. As long as it could be structured in a way that it could be left under your will to qualified transferees, you might save 5 or 4.5, 12, or even 15%. Let's take another example. Let's say you have a family-owned car dealership which has multiple stores. Each of those could be divided into separate businesses at a very, very low cost. If each of the businesses had a book value of less than $5 million, substantial value could be transferred to your heirs without any inheritance tax and with a very modest upfront transactional fee. One more example. If you have a service business or a manufacturing business organized as a partnership or a corporation or an LLC, and it also owns IP, intellectual property, such as software or patents or trade secrets, it might be possible to divide or separate off the marketing, the management, the production, and or the IP ownership into two or more businesses, which again would each have a book value of less than $5 million. Fair market value could be much higher, but you're going to transfer them to the recipients without Pennsylvania inheritance tax. This could produce a massive inheritance tax savings. So who's this for? It's especially powerful for families that own real estate, commercial or residential, which have high value and low book value. It's good for owners of LLCs, partnerships, and corporations. It's only for Pennsylvania residents or those that are subject to inheritance tax here. And it's for families that own businesses of any type that you're not planning to sell, but instead to pass on to QTs, qualified transferees. It's only for families passing these assets to other family members. It's for people who are tired of being told that they have to give away all their assets prior to death in order to be able to save taxes. With this new law, you may be able to hold on to your assets and continue to derive the income and wealth that they produce and to pass them on tax-free. It's for families that want to keep their options open to either protect assets from divorce or lawsuit or to trigger these large tax savings. Who's it not for? It's not for you if you're planning only on selling the business to people who don't qualify as QTs. It may not work for you if you're leaving it to a son-in-law or daughter-in-law. It needs to be reviewed carefully. If you're single and your assets exceed $5 million, or you're married and your assets exceed $10 million due to federal estate taxes. And it may not be for you if you have overriding reasons to leave the business to your heirs in trust rather than outright, since that's not permitted under the new law. It's also not for you if you're not willing to spend the fees it might take to revise your will or to create new businesses that qualify if yours doesn't already. But really, you're not going to spend that money unless you're getting gigantic savings or significant savings to justify it. So what's the next step for you? If you've been listening to this and thinking, that might be for me, I might be interested in that, I need to know. I mean, how can I go from this complicated system to easy? Well, generally, it's not something you're going to do on your own. It can be simple and sometimes only needs a little change to your will. But the law is complicated, and you should seek the advice of a lawyer or firm with experience in both business and trust and estates planning. And you want to give them your facts. They want to base that advice to you on your particular circumstances. In some cases where your business book value is below $5 million, this can be as simple as doing a new will with our QFOB protection plan. In those cases, the cost can be $2,700, in some cases even a little less. And updating your will will also give you additional benefits like powers of attorney, living wills, medical powers, and more. In other cases where the savings can be massive, you'll probably also want a lawyer who will help you to divide businesses or structure them the way they need to be structured, and will coordinate with your accountant, as there may also be some lifetime income tax issues related to some of the planning techniques here. You may also want them to consult with your insurance advisor, since some of this planning can involve changes that might mean small or even significant changes to your personal and business insurance coverages. So whether you're looking at saving tens of thousands or hundreds of thousands of dollars on inheritance taxes, we have a process that can help you, and it's going to be appropriately priced. It's going to help you to find out if this is for you and to get it done in one streamlined process. Now, the way we do this is with a telephone call. We can help you to find out pretty quickly and easily, probably in as little as 10 minutes to half an hour, whether or not this is for you. Each month, we set aside a limited number of appointments for family business review and protection calls, where we could go over this with you. We have to limit the number of calls because they can range, as I say, anywhere from 15 minutes to half an hour. And we can only do so many since we also need the time to do the work for clients who do decide that they want these savings and these will updates. So if you have a family-owned business and you'd like to discover if this new law in our process could result in significant tax savings for you and your heirs, and in some cases for asset protection for you, then there are two options. If you're an existing client, then just call 1-888-808-5464 and ask for one of our family business consultants. You're going to get me, Doug Kahn, or one of the other lawyers that's been specifically trained by us to help you with this. And you, as an existing client, you get priority on these review calls. If you're not a client, this is our second option. You can call the same number, 888-808-5464, and ask to schedule a family business review call. There might be a short wait for you for that appointment because we give priority to our existing clients, but you'll be scheduled as soon as possible. While there's no charge for these calls, the fees for the process can range from as little as $2,700 up to $10,000 or more. I mean, you're not going to pay that unless you're getting a significant advantage. It depends on exactly what you want and need, but there's no risk or obligation to you. The call is totally free of charge. And during the call, we ordinarily can quote you a flat fee or give you a very close range of the costs involved. But you're never going to spend that money unless your heirs are going to get a significant savings and inheritance taxes, and in some cases where you're going to get that additional lawsuit protection for yourself. There's no risk to you and no obligation to proceed with anything after the call. In fact, we believe that many people, many small business owners that call, ultimately when they understand it, won't actually want the program, or they may not need it. It may not be for them. And if you're already set or it's not for you, we're going to tell you that too. But for those clients and business owners who are planning to leave a business to a child or other family member, This could be a huge, huge return on investment of your time and the money and the costs involved. So if you'd like help with deciding on whether to try to protect your business from inheritance taxes, and if the answer to that question is yes, and if you'd like more information on how to do it, then call 888-808-5464. If you're interested in sheltering your business from inheritance taxes and you'd like our help with that, make that call. Thank you. I appreciate you taking the time to listen to this report, and I look forward to talking to you. Please also remember that the information in this video is subject to change. Pennsylvania laws change all the time. And it's not provided to you as legal advice because we don't know your circumstances. It's only an alert to you to get legal advice from your legal and tax advisors based on your particular circumstances.